May I state most emphatically that the old gray mare ain't what she used to be? No, sir. She's a whole lot better. I make this remark, gentlemen, to emphasize the fact that progress marches on. A situation of which we must all take cognizance. You all know, probably better than I, that roads throughout the entire country are not what they used to be. And you gentlemen are justly proud of the beautiful highways. Some of them are 8 lanes wide, which grace our glorious state. It was on such a road that this young man was traveling. All laws must be interpreted in the light of progress. But please, gentlemen, do not misunderstand me. The evidence the defense has offered in this case is not based on any apology for recklessness. Laws and customs change, and sometimes it is indeed difficult for the letter and interpretation of the law to keep step with the progress that our noble modern civilization is making. Not only have roads improved, but cars that travel on those roads have improved. This is a day when modern cars can travel in safety at speeds that once were impossible. Gentlemen, is it unsafe to travel along an uncongested highway at a speed of 70 miles an hour in a car that can do all day 80 or 85 and upwards?
Well, what happens if he hits a bad spot and has a blowout?
We travel on improved highways today. But gentlemen, even though an obstruction had lain upon the road, it would not have presented any danger, because, as we have shown, his car was equipped with the most modern devices for lifting a wheel over such an obstruction. And even though a front tire blowout had occurred, owing to the wheel's construction, it would not have endangered the defendant or anybody else. Was he reckless, gentlemen? When we consider that he, along with other drivers of most modern cars, is protected by bodies of solid steel with turret tops. Gentlemen, this officer has told us that he fell before the defendant's car. I firmly believe that when we consider the testimony as to how it happened, that you will agree with me that he should rightfully be considered the defendant in this case and charged with recklessness, if any. Gentlemen, this officer has confessed that he was stealthily concealed behind the shrubbery along the parkway, in hiding, ready to pounce upon any unsuspecting victim that might happen by. The defendant came along in perfect control of his car, though admittedly driving rapidly. Gentlemen, can you see the look of joy on Officer Crane's face as he mounts his motorcycle and takes after the victim? Follows him for some little distance and then deliberately, recklessly drives in front of the defendant's car. He skids and falls. It is fortunate indeed that the defendant's car is under control. But is Officer Crane grateful? No, gentlemen, I think I may say with perfect assurance, he is not. And finally, gentlemen, it is not too much for me to say that all charges of recklessness which have been brought before you have been wiped out by the safety which the defendant has demonstrated in the power, speed, safe construction, and control of the defendant's car when he saved the life of Officer Crane, that he might come here as a living witness to the safety of the defendant's manner of driving. Safety is the purpose of the law. And the question of whether the young defendant was proceeding with recklessness in one hand and safety in the other should form the basis of your verdict in this case. With due regard to his honor, and the law which prohibits reckless driving. Safety, gentlemen. I'll repeat. Safety. I thank you.
Gentlemen, the defendant in this case is charged with reckless driving. In the usual course of events, the testimony would be presented to you for your consideration. However, in this case, I am constrained to follow a different proceeding because the testimony is beyond dispute. Outside of city, town, or corporate limits, there is no definite speed limit in this state. Therefore, it must be definitely proved that the defendant was driving recklessly. The only testimony as to recklessness was that he was driving at the rate of 70 miles per hour. But the testimony also shows, however, that the defendant was driving a car of modern make, equipped with each of the most advanced features of safety and control. The presence of Officer Crane in this courtroom today is sufficient evidence and counteracts any charge of recklessness made against the defendant. It appears that under the circumstances, there's no competent proof of recklessness. Therefore, you members of the jury are dismissed. I wish to thank you for your attention. And the defendant is discharged. Oh, Mr. Norton.
Where can I get a car like that?
What? You?
Jack, come here.
Say, you got your order book with you?
Yes.
The judge wants to do a little business with you. Yeah.
Are you sold, Dad?